Rocking and rolling. We are live. All right. So welcome everybody to today's, let's call it an education session. It's really about Kayla. She's I'll get you to introduce yourself, but a great resource as part of our family. I really do look at it at people like Kayla as part of the family, part of the team here at for Contractors. And we're all about helping contractors really have a better business, have a better life, and get the profits paid for their freedom. And one of the key aspects of making that happen is making sure that you're getting the answers to some of your questions, and even more importantly, knowing what the right questions are on the legal front in running your business, especially during these times like COVID-19. So introduce yourself there, Kayla. I know a lot of people know you, some people don't, because we've got a lot of new people that are now part of the family. Tell us a little bit about yourself and where you're at, and let's get into this.
So thanks so much, Andrew, for having me. I know I've worked with a lot of you before, so some of you know me, and I know a bunch of you as well. But for those of you who don't know me, my name is Kayla Wkwinter. I am a lawyer specializing in construction law. I work at a full-service law firm in Toronto, Ontario called Tork & Mains. So as I say, I specialize in construction law, particularly in litigation, but I do draft contracts as well. But I work with about 100 other lawyers who work in a whole range of areas. So if there's questions that you have that pertain to other areas of the law, I know employment is a big issue right now. I can get you help with that stuff as well. So, and I've worked with some of you before on legal issues that you've had. It's always a pleasure. I love working with contractors, clients.
Well, we're very lucky to have you in our corner. Okay, like literally. Well, let's face it, right? Like, I'm just going to cut to the chase. I've had to deal with the law, right, in my days, in different ways, different aspects, and I think a lot of people can be intimidated by lawyers. A lot of people, can frown upon lawyers because I think, there's people that have experienced things where it's sort of, it's a little bit painful or it's a little bit challenging when you get a knock on the door, whatever that might be from a legal perspective. With that being said, it's that much more important now than ever that you have people like yourself in your corner, because you really need to protect your business. And when you have the right people in your corner, I think I think you're great, Kayla, and I have a different perspective on lawyers because I'm able to see the other side. I'm able to see people like yourself proactively addressing things so that people are like, oh man, I didn't think about that. Like, yeah, you should get this in place. And it's just like, hey, now I feel, I feel better because I've got the right protection. I've got the right backing behind me. So let's talk a little bit about what we're going to be addressing today. Like what's on the platter today?
So I think actually I want to start by touching on something that Andrew and I were discussing before this call, which is that, this is a tough time for everyone, but this is not the end of days, right? And I think that the really important thing that we all need to be thinking about right now is how to make sure that we just weather what's happening right now, keep our business running, keep it going, do what we can do to get through this time that's admittedly going to be challenging for everyone, but be best prepared for when we all come out the other end of this, and we will come out the other end of this. Totally. So there are certainly a few unique challenges that are going to be faced during this period, and I want to talk a little bit about those. And I'm happy to take questions that anyone has. If your questions are general and have sort of application to everyone, I can most likely answer them on this call. If you have a specific legal issue that you need advice on, we can chat later.
Okay, perfect. And as far as your information goes, let's make sure as we go through this that we put that into the chat. For those that are part of the Champion CO group, you guys can put your information there, but and we'll actually put it to you guys right now. That's on this call inside the Zoom. Let's put the link inside here so that the PFC Champion CO family can get access to you. For those of you that are joining in, say through the Contractor Tips group or things of that nature, do your best to put the questions up in there. Kayla is also part of that group as well. and she can help guide you as best as possible. So,
yeah, and feel free to post questions in the chat window here. And if you have a question that you'd like to ask, you can raise your hand on the Zoom platform, and I'll unmute you.
Yeah, absolutely. You can raise your hand, or if you want, just type in the question in the chat, and it'll pop up, and we'll be able to see it. So let's get into some of the things that maybe you've been hearing. Some of the questions or some of the thoughts. Let's get into the question in a second. But what's some of the things that you're seeing out there on the construction world?
So I think the biggest question that I get asked as a construction lawyer is, what can you tell me about construction liens? I get that pretty much every time I chat, and every time I speak with proper contractors clients, regardless of what the topic is of the seminar, it always ends up turning to liens. I think liens are the big question that contractors have. And it's good. It should be your biggest question, because as contractors, it's your biggest security. Most other businesses, most other people don't have the leverage that contractors have by having access to the lien remedy. So I always tell contractors when I speak to them, it is your biggest leverage, it is your biggest asset, and I would think very carefully before you let liens expire if you're waiting for payment on a project. And I should also just mention that because I practice in Ontario, most of the information that I'm going to be sharing with you today is specific to Ontario. It's applicable in Ontario. If you live in another province, the information may be similar, but it's not going to be identical. And if you live in the United States, again, there is a construction lien regime in the United States, but you're going to have to consult with a lawyer in your particular state for advice about the laws there. I've been chatting with Lien and with Andrew about putting together some referral lists of good construction lawyers that we've worked with in the States. So if you do want a referral to a construction lawyer where you live, you can chat with Liam, Andrew, me, and we'll find someone to set you up with.
I love it. With that being said, since that topic comes up all the time, how does that play into what you're seeing out there with this COVID-19? Like, do you see, has it been like amplified, the inquiries about liens? Is it, would there be any sort of tips that you would say regarding, hey, during these times you really want to consider this because it's a little bit different? I don't know. Like, what's your thoughts on liens in this particular moment in history, basically?
Yeah, there are a few things that I think are important right now with respect to liens. So the first thing is, the bottom line is, this is a challenging time. It's taking a toll on people's businesses. The lien remedy, if we go back to first principles, what the lien remedy gets you is it gives you a right against the property. It gives you an interest in the value of the property that you've helped improve, because you as the contractor have helped increase the value of that property. And so the philosophy is that you should be entitled to share in the increased value of that property.
I'm just going to say, you just really gave such a great description. I've tried to describe people like, people that are new to contracting, like say they're new, like 3-month-old, 6-month-old contractor. Like, so Andrew, like, explain to me a lien. Like, what is it? And then I explain it. They're like, I'm like, you're more confused than where you were before we started this conversation, right? You nailed it,
Andrew. There you go. You can tell people that's what it is. You've improved the value of the property. You should be entitled to share in that. And the other thing is that when you look at the model of a construction project, if you've got a developer at the top, if you've got a homeowner at the top, they're the money, right? And so they're the people with the money, and the money needs to flow from them down to you. And as you go down the layers of the construction pyramid, the money trickles down more and more slowly, and it gets more unfair and more difficult to be lower down the construction pyramid because you're farther away from the ultimate source of the money. And so the point of the lien is to take a person who's anywhere on the construction pyramid and put them as close to the top where the most money is as possible. So what I'm telling people right now is, wherever you rank on the construction pyramid, whether you're a general contractor, a subcontractor, a sub-subcontractor, a supplier, you've got layers of people above you who may weather this really, really well and come out the other end as strong or stronger than they were before, or they may not. Oh, shoot. Sorry, guys, I'm getting a message that my internet connection is unstable, so if I disappear for a second, I promise to come back. So given the value of the lien remedy and what it can do for you,
no, you're good. You're good. Keep going. Keep going. You're good. Looks good on this end.
I'm good. Okay.
Yeah, you're good. You're
All
good.
of you are frozen now.
Okay. Well, we can hear. I can see you fine.
Perfect. Thanks, Andrew. Given the value of the lien remedy and what it can do for you, I think this is a really important.
I spoke too soon. I did the old.
Have projects where funds are not flowing, and you think the reason.
Uh-oh. I'm sure I'll come back. It's just getting it was just about. I was waiting for the. But
Sorry,
it's
guys.
Okay, it's all right.
Sorry. So, as I was saying, if you're working on a project right now and funds are not flowing as they should, and you think the reason that the funds aren't flowing as they should is because somebody up the chain from you is having financial difficulties, especially if you think they're arising out of the COVID issue, registering a lien is a very good idea. It protects the money that you have invested into the project. It protects the profits that you intend to earn on the project. And again, a lot of people out there don't have that opportunity. So there are lots of businesses that are struggling because people can't pay their bills, but they don't have a right to register a lien against property and actually share in the value of the property.
Right.
So for that reason, I really think that now more than ever, liens are really important, and you guys are really lucky to have access to that remedy, and I really encourage you to take advantage of it. The other thing that I like to make sure that I tell people up front, and this is very specific to my firm, and so if you're in Ontario or you're working on a project in Ontario, I can help you with this. If not, the information you get may be a little different. We can usually register a lien for about $500 to get the lien preserved against the property. And then the process for registering a lien is that you first preserve your lien by registering a claim for lien, and then 45 or 90 days later, depending on which act we're operating under, you have to perfect your lien by starting a lawsuit. So that first step of registering the lien we can do for about $500. The second step we can usually do for between $1,000 and $1,200. And then if you have to get into litigation, that's where legal costs start to increase. But you don't have to start really aggressively litigating right off the bat. And so you should expect to be in for, something between $1,500 and $2,000 to get the lien preserved and perfected. But that's really the cost to get your rights protected. And I just like to make sure that people know that, because I know that there's a lot of misinformation about how much liens cost and how it works. And
let me ask you this question: and I know it might be a question that you can't answer from a statistical perspective, but what do you typically find when those first couple of steps happen before it goes to litigation? Do you find that has a dramatic impact on changing things as far as the position of where the contractor's at with the client?
Every situation is different, but certainly if you register a lien, people take you seriously. They know that you're serious. They know that you're invested, and definitely it encourages early settlement discussions. Which I think is the best way to go. I mean, if you've got a huge account that's over $100,000, over $500,000, sometimes it can be worth going through the whole litigation process to get what you're owed. But if you've got a smaller lien that's $20,000, $25,000. It's a lot of money to you. You don't want to just walk away from it. But it's not necessarily worth spending the money that it might cost to aggressively litigate it. Having the lien registered certainly just puts you in a position where you're showing that you're taking this seriously, you have leverage, and if you need to go the distance, you will. And I think it can be very, very helpful to help move the parties to an early resolution.
I love it. So Chris's question is,
how soon should you start the process?
Yeah.
It's a great question, Chris. So when a lien is relatively straightforward, we can turn it around pretty quickly. But the more time you give us, the better. So I love it if clients can reach out to me a week before their lien expires. I don't necessarily need more than a week. A week is a good amount of time. We can do it in less than a week usually. It just sometimes something comes up and you've got an issue and there's just no way around it and you don't have enough time. A week is usually enough time to really make sure that we can get everything dealt with.
And actually, I'm just going to mute Chris. Chris, how's it going, brother?
Hey, not too bad. How are you?
Good, lad. So tell us a little bit about what's just a little bit about your experience with this. Have you had to put liens on people and stuff like that?
I should have. A few years back, there was some people that had made a whole bunch of, changed the scope, extras and those sorts of things, and we kind of did everything on a handshake. And then when it came time for, to start charging for the stuff, they were changing their mind. The reason why I'm asking today, though, is we literally just finished a job yesterday. It was a spray foam job. And at midpoint, the clients came in. I shouldn't say that. After the first day, they came in the second day before we were done, and they were just asking if they could add an extra inch on the ceiling and, a bunch of different things. And, learning from what from the lesson from the last time, I said, yeah, no problem. We can do that. We're here. We're set up, and I'll have Bill in the office give you a call. So he called them and basically just said, oh, hey, you're just looking for a confirmation. You guys want that? Do you want a separate estimate, or do you want me to just rearrange the estimate that we did and send it back to you? And then once they realized that we were going to charge them more, their attitude changed, and they came in and they were just picking it apart. And, we just kept saying, we're not done. We're not done. We're not done. And so I can already sense this client is going to be putting up a fight. And so I'm just wondering, because we're going to send the invoice in today, and I'm just wondering, I was going to put it due in 15 days. And I'm just wondering if I should wait until that 15 days. And if they haven't paid, apply right away for the lien, or when.
So you're asking all the right questions. And I'm going to give you guys some kind of technical information, so bear with me because it's a little boring, but I think it's really important.
And Kayla, can you do something here, which is that, and I'm pausing because I think this is pretty important. Reiterate what those questions are. So everybody listening in, whether you're listening to this recording or not, you want to grab a pen or grab your phone, because Chris asked some really good questions. And if you miss one, or you do half-ass after listening to this, well, then you're going to risk getting half-ass results. So what were some of those questions Chris asked that resonated?
So Chris has asked two different and equally important questions. And I'm going to put them in the opposite order that he's asked them in. But the two questions are, when does the lien right start? Chris, you've said, does it start on the due date of the invoice? I'm going to rephrase your question a little bit to say, when do my lien rights start, or when do they end? And then the second question is, when should I start the process of registering a lien? So the first question is a legal question, and the second question is a strategic question. So I'm going to start with the legal question, which is, when do lien rights run? And again, it's a little technical, but bear with me because it's important. We're in a bit of an awkward time right now in Ontario because our lien legislation was recently overhauled, and there are now 2 different versions of the Lien Act that are in place, depending on when your project was started. And the way that we've structured things, which is good but leads to some complications, is that the version of the Act, the same version of the Act applies to a whole project. It doesn't apply to, one Act to contractors and a different Act to subcontractors. It's the whole Act to the whole project. The problem is that the trigger for which Act applies is the date that the head contract was entered into. So that's the contract between the owner of the property and the general contractor. And if you're a sub or a supplier, you may not know when the head contract was entered into. What we do is we assume if you don't know the date that the head contract was entered into, we just use the more restrictive one because we don't want your lien rights to expire. So the rule of thumb is if the head contract was entered into before July 1st of 2018, you're under what we call the old Act. If it was after July 1st of 2018, you're under what we call the new Act. Under the old Act, the lien period was 45 days. Under the new Act, it's 60 days. So it's important. It's okay to get it wrong and assume that it's 45 days because you're always going to be okay if you lien within 45 days. You don't want to make a mistake and think that your lien period is 60 days only to learn that it was 45 days. So when in doubt, assume 45 days. To make a quick detour to the strategic question, I would prefer right now and for the next year or 2 years until we sort of get out of the phase where 2018 projects are still underway, I prefer for clients to come to me on day 40 and say, which Act am I under? How long is my lien period? And I may be able to tell you, I think you're fine. Your lien period is 60 days. You can come back to me in 20 days. We can do it now if you want to, but you've got a lot of time. Rather than people come to me on day 55 and say, I have 5 days left to register my lien, and I look at it and I have to tell them, actually, your lien expired 10 days ago. Sorry. So on the how soon should you start the process, I'm still recommending that people assume their lien period is 45 days because the 60-day period doesn't apply to all projects. Okay, so going back to when the lien period runs, whether it's 45 or 60 days, the trigger for the lien period is the same. It is not the date of your invoice. And that's a very common mistake that people make. The lien rights have nothing to do with your invoice. And there are a few important pieces of that. One is the date of your invoice doesn't matter in terms of your lien rights. Another is the amount of your invoice doesn't matter. What does that mean? Your lien right is for the value of labor, services, and materials that you've supplied to the project. As soon as you start supplying, you have a lien, and you have a lien for the value of what you've supplied so far. What that means is if you've invoiced up to the end of March, and now we're in mid-April, and you've done more work in April, you've got a lien right for the work you've done in April, even though you haven't liened for it yet. Likewise, if your holdback hasn't become payable yet, you still have a lien for that holdback amount, even though it's not owing to you, it's still accrued, right? You've still earned it by contributing that value of labor, services, and materials to the project. So neither the value of your lien nor the timeliness of your lien is actually related to your invoice date. The date of your lien is the date of your lien rights is determined as follows. Under the Act, we talk about 2 different people. There's a contractor and anyone else. A contractor is a person who contracts directly with the owner of the project. Anyone else is anyone down the chain, so a subcontractor, a sub-subcontractor, a supplier. If you're a contractor, meaning that you contracted directly with the owner of the project, your lien rights expire 45 or 60 days after the date that your contract was completed or abandoned. So if you finish the project, that triggers the date for your lien rights. If you walk off the job or you get fired from the job, that triggers your lien rights. it is safest to assume that the last day that you are on site triggers your lien rights. But the reality is that we see a lot of situations where you might show up to site one day, the owner says, oh, I don't need you here for the next few days. Come back in a week. I'm working out some design issues that I'm having, or maybe you're having a payment issue and you say, look, we're not walking off the job. We're coming back, but you have to pay us first. And the owner says, well, I don't like your account, and you're fighting about that. So you're not actually working on the project, but the project's not finished and you haven't abandoned it. Your lien rights can actually survive for quite a while. But those issues get very tricky, and they're legal issues that ultimately are left to a court to decide. And so the safest thing to do is to diarize your lien rights from the last day that you were on site.
What does diarize mean?
Sorry, thanks, Andrew. Just note it. Just write it down. Just say the last day that I was at this project was this date, and I'm going to calculate my lien rights from that day forward.
Is 100% is completed? What is completed defined as?
That's a great question. The Act actually has a definition of completion, and it's a different definition under the old Act and under the new Act. It's about when the project has either 1% of the total cost left to complete or less than $1,000. I think under the new Act, it's less than $5,000. Okay. So it's not 100% completion, but it's also not substantial completion, which is a different defined term under the Act, right? It's so, which again, this is why I say the safest thing to do is to just note your last day on site and say, I'm going to talk to my lawyer. I'm going to assume that my lien rights expire 45 days from that day and talk to my lawyer, and then we can figure out from there when they actually expire. If you're anyone else, so if you're a subcontractor, subcontractor, supplier, your lien rights expire 45 or 60 days from the last day that you supplied to the project. So that's if you're a subcontractor and you're actually supplying labor on site, your lien rights expire 45 or 60 days from the last day that you were physically on site doing stuff. If you're a supplier and you're not actually on site supplying labor, you're just supplying screws or lumber or whatever, your lien rights expire 45 or 60 days from the last day that you delivered the material to the project.
With the same term of completion.
So no, it's not. This one isn't a completion. This one is the last date of supply. So it's a lot more straightforward. It's just the last day that you supplied to the project.
Okay, cool. Okay, that's easier.
And so if you, now what that means is if you supply to the project on March 1st, and then you don't go back to the project for 3 months, technically your lien rights have expired, right? You have to lien within that. You have to lien 45 days from the last day that you supplied to the site. If you go back 3 months later to supply more labor services or materials under the same contract, that extends your lien rights. But you've got to be careful because sometimes people try to go back to do something in an effort to extend their lien rights, and that gets very complicated. So if you think your lien has expired and you think, oh, well, I'll just go back to the site and tighten up some screws and say that I did work. That's not typically looked on very favorably, and courts will usually not conclude that has extended your lien rights. So the question to the legal answer of when does my lien right, what triggers my lien rights and when does it expire? It's 45 or 60 days from completion or abandonment if you're a contractor, and from last date of supply if you're a subcontractor or a supplier. But the answer to the other question of how soon should I start the process, my very strong advice is, in every case, just note the last day that you worked at the project and talk to your lawyer by the 40th day after you last supplied to the project. Because if you do that, you'll never lose your lien right. You'll always be 5 days before your lien right has to expire at least. And you may talk to your lawyer and find out that actually you've got lots of time and you've got 60 days on this project, or you're actually, that wasn't really the trigger date and the trigger date hasn't happened yet. But that's my rule of thumb is by the 40th day from the last date on site, start pursuing your lien remedy if you haven't been paid. Now, there are obviously, one question that comes up a lot is, well, my holdback isn't due yet, so I haven't been paid my holdback, but it's not due yet. But if I wait until after the holdback is due, then my lien rights have expired, because holdback becomes due after all the lien rights expire. That's how holdback works. So what am I supposed to do in that situation? Do I lien because I haven't been paid holdback? Or do I wait, then find out that I'm not being paid holdback, and then I've lost my lien rights? And the answer to that question is always, do you think you're going to get paid your holdback? Has the owner given you, or the contractor given you, some indication that they don't want to pay your holdback, that they're upset with your work? Have there been payment issues in the past, right? If you have a reason to suspect that you're not going to be paid your holdback, then it might make sense to lien for your holdback. If your accounts have been paid on time every month, you've never had an issue with holdback, or you've never had an issue with payment, and the owner's been telling you that they're really happy with your work and they're going to pay you the holdback as soon as it becomes owing, you probably don't need to lien for the holdback.
Okay, good advice. Chris, does that help address your question?
Okay.
Thumbs up? Okay, good man. Okay, Peter asks, are we able to recover the cost for registering the lien? Peter, unmute yourself for a sec.
Hey, Peter.
Oh, hi, nice to see you. The issue that we have is a lot of times our projects are not a large amount, right? So it would be like between $3,000 and $5,000 to register a lien and drop $1,500 into registering a lien. It doesn't seem to be very. It's not a good thing for us, right? So I was wondering. I mean, if you went through this process, and it happens quite often, $3,000 to $5,000, we seem to get a lot of people that delay the payments, and in a lot of cases, I'd like to put the lien on, but I'm hesitant to doing so at $1,500, right? If we went through that process, would we be able to recoup the money? Like when we?
Yeah, so that's a really great question, and I'll start it by acknowledging that $3,000 to $5,000 is a really tough amount to be owed, because you're right, it's a small amount in comparison to legal fees, but a big amount for you, especially if it's on a bunch of projects. So the long answer, to whether you can recover your legal fees is, the law in Ontario is that if you successfully recover in a lawsuit, you're entitled to recover about 60% of your legal fees. In certain cases, you can increase that to closer to 90% of your legal fees. But the Ontario has a sort of loser pays system. So if you win, you're entitled to at least a portion of what you've spent on legal fees. The problem with a $3,000 to $5,000 lien and recovering your legal fees is that you're not going to go to court on a $3,000 to $5,000 lien. You're going to settle, and so it's going to come down to whether you reach a resolution under which the other side agrees that they'll pay you your legal costs of registering the lien, or whether they say, "Oh, okay, we'll pay you here. We've paid your account in full. Now go away," and then you have to say, well, I'm not going away until I get my legal fees. And then you're in a kind of loop where you're spending more money to try to negotiate with them to pay your legal fees. So it's a tough amount, because the answer is, yeah, you're entitled to your legal fees. Are you going to get them? Not necessarily. It depends. So a couple of recommendations that I make in those situations are, one, you can preserve your lien, which as I said is about $500. Spend the time between preservation and perfection trying to get paid with the threat of, I've registered a lien and I intend to pursue it, but then don't pursue it and don't spend the extra money to perfect it and just let it lapse, which gives you the initial strategic advantage. But of course, if you don't get paid in the next 45 or 90 days, depending on which act you're under, you kind of lose that whole leverage that you gained in the first place. The other thing that you can do is, if you're working for the same owner or general contractor on a whole bunch of projects, rather than registering a lien, what you may want to do is, if you find that over a period of time, you're owed a bunch of money on a number of projects by the same person, you may just want to start a lawsuit. There are a few different nifty ways to do that as a contractor, and you may want to just group all of the projects together and start a lawsuit that deals with all of them. Unfortunately, you can't group them all together for the purpose of a lien, but you can for a lawsuit.
Okay.
Does that help, Peter?
Yeah, it does.
I got so many things going through my head right now as far as like it's. I think this is where there's so many, and I know this is like a bit of a side conversation outside of on the legal front, but we got to really be looking into all the options of protecting ourselves, especially Peter in your type of work, or the value in that particular application, that range, to provide the financing, to provide different ways for them to pay quickly, to get upfront payment if you can, because at the end of the day, if it does come down to it, it's a fine line as to whether or not it's going to be worth it. That's financially. Then you add in your time and your stress, and this is the other side of it. It's too bad, and it's something that maybe we could talk about a different discussion. Is if there's some way to check the credit of people, if we can have some form of systemization to. And Peter, how do you do that? Is there some way that you guys pre-filter prospects or clients from a line, like from a that they're credible?
Well, in some cases we're working for landlords and they won't show up on site, and we'll be talking to them on the phone and they'll go ahead and do the work. So what we've done for them is we pre-authorize their credit cards now. We're not even going to do any more work for them. We're just going to say it's just like going to the hotel and they're going to put $500, $600, whatever we think it is, on hold. And if you don't want to do it, we're not doing the work for them. So
I love that. Smart.
That's how I dealt with that. The one that really causes me a lot of like where I would love to lean is our restaurant owners. Restaurant owners, we end up getting into a maintenance contract for them for a lot of the work that we do. And we'll get their credit card for the maintenance aspect of it. So the routine stuff that we do every month, we get their credit card. But where we get stung is because we have the contract with them that they go ahead and get the plumbing end of it done. So I'll have a restaurant owner, like they'll gather, like an average job for us is $500 to $600. And so, we'll be into 60, 90 days where every month we've done $500, $600. So, and then we end up getting stuck with this, again, anywhere from $1,500 to $3,000 bill where we're chasing it forever. Right. And so, in some cases we're able to collect it, and in other cases we're not. And so you sort of get down this road, and then you don't want to stop doing work for them because you get the routine maintenance for them, but you get stuck with the plumbing end of it. And
why are you not putting it on the credit card? $500.
So we can only authorize the credit card. We can only pre-authorize a certain amount every month. We can't just take whatever we want out of that credit card. We can only, let's say the contract for pumping the grease traps is $300 a month. We can only take that $300 a month. I can't take any more. So unless they authorize us to use that credit card for the plumbing services, we're stuck, as far as I know.
Mm-hmm. Yeah, there's Nathan asked a similar question about rules surrounding credit card information at the beginning of the job. I'm not aware of any restriction on collecting that credit card information. But I think Peter's right that you can pre-authorize a certain amount of money, but you can't charge someone's credit card without their authorization. So even if you have their credit card information, if they haven't given you the authorization to charge the credit card, you can't just charge it because they owe you the money. And if you do charge it, the credit card company will just reverse the charge. So that's not a helpful option.
Do you think if we changed our contracts to basically say, this is how much we're going to charge you for your routine maintenance, and if you use our plumbing services, we'll use the same credit card and charge that amount?
You know what? I think that's a question for the credit card companies, but it sounds reasonable to me. I mean, you can say we're going to be. The other thing I wonder if you could do is if you could include on when you do. Sorry, Peter, I just want to back up. What's the nature of your work?
So we'll do plumbing and drain cleaning. Mostly for the restaurants, we're doing drain cleaning and grease trap pumping. Okay. So more of a maintenance of the infrastructure.
And when you work with clients, do you have a written agreement with them?
For the maintenance, yes.
Okay. And so you enter into a written agreement for the maintenance work. When it's plumbing work, they just call you on an as-needed basis and you show up?
Yeah, and we write up an invoice for it. So we do have we have an invoice for that work.
Mm-hmm. Because I wonder if there's something that you could have your customer sign when you show up to do the plumbing work that pre-authorizes their credit card in the same manner as it does with the maintenance work, so that you're not chasing them after the fact. And when you're showing up at a client's restaurant to do plumbing work, they need the plumbing work done. You're there, they're there. That's a good time to have them sign something that authorizes you to charge their credit card rather than having to chase them after the fact.
Yeah, and I would agree with that, but usually the owners aren't there. Their staff or the head chefs are there and stuff. And we've had that discussion with them before, and they're saying that guy doesn't have, or that girl doesn't have authorization to sign on my behalf, right? And they come up with every excuse, Meanwhile, we're still chasing 60 and 90 days down the road and more.
Right. Now, the maintenance, are you able to pre-authorize for the maintenance because it's on a regular schedule?
Yeah.
Okay, so you know up front that you're going to be providing X maintenance on this particular schedule.
Yeah.
It's an interesting question. Let me think about it. I'm going to ask around and see if I know if I can find any models that other people have used.
Yeah, that'd be great. I mean, I think at the end of the day, this is why you're here, Kayla, but end of the day, what my logic behind it would be is if it's reasonable terms, they've agreed upon that, I think you're probably going to want to put some sort of limiter in there, Peter, say up to. You know what I'm saying? Yeah. Then there's this process, right? And I think, I don't know. I think this is very worthy of Kayla looking into, because I think there's a lot of people, that are facing, or have been facing, and are facing those kind of challenges. I got a bit of a question for you, Kayla. So, and maybe you've addressed it, but I gapped. I'm not sure. We'll see. So you got this contractor. You're working on the job. Let's just say they're a subcontractor. This COVID-19 comes along. They were like 85% done. So let's just say that's the bill that was outstanding. It was going to be 2 days. Some of these trades, I know even back in my day, I could get that 15% done in especially coming to the end of a job. It can accelerate, right? That the finishing of a job, that 10% is not in most people's minds. They're like, oh, that's equivalent to, because it's been, it's 3 months, so it must be 2 weeks. No, it's 4 days, or it's a half a day. It's going to be done. And now this job's been put on hold. Am I to understand that they don't have any rights at that stage because of this scenario? So you know what I mean? To put a lien on and to leverage the lien, because it's hey, you didn't complete it. You still have 15% left to do.
So is the example that you're giving, you're a subcontractor. Yeah. You finished 85% of the work. And now the contractor, the owner says, I don't want you to work on this project anymore. I'm putting things
or it's been shut down or something. Tomorrow I was going to be, I would have had this thing done by noon tomorrow.
And now it's being put on hold.
Yeah, and it was $80,000 sitting there. That's owed to me.
So the answer is that it's going to depend on your last day on site, right? So if your contractor, again, and you've contracted directly with the owner, then the day that the owner tells you, I'm putting this project on hold, I'm canceling the project, whatever, that's going to constitute the trigger date for your lien rights, because that's the day that the contract was abandoned.
Okay. Yeah,
and maybe it's not truly abandoned, maybe it's just put on hold, but you may want to assume it's being abandoned for the purpose of calculating your lien rights. If you're a subcontractor and the contractor tells you the owner's putting this project on hold, don't come back to site, we're stopping work, we're suspending work, whatever. As long as you were on site in the last 45 days, you've still got lien rights and you can register a lien. If it's been more than 45 days since you were on site, and for some reason you were just waiting to come back to do the last 15% of work, then you're going to have an issue.
Yeah, that's what I thought you were going to say.
Yeah.
Darn it. I got one more question, but I'll let Nathan pop in here. On your invoices, can you get the customer to sign an agreement saying that at 40 days after the invoice is received, your company is authorized to charge the card on file?
You know what? I don't know the answer to that question. I'll look into it. I think that's a credit card company question, but let me look into that.
Very cool. Okay, awesome. My question to you is this, and then we're going to start wrapping things up, is moving forward. So these lovely people, everybody listening in, you're a contractor. Times have changed. So you're say for example, you're about to kick off a job, and you're just about to propose a contract with a client. Okay, so you're going to give a quote to somebody. Are there any adjustments or changes that you would suggest, i.e., draws, things of that nature, that you would emphasize more with today's situation than the past? Is there any tweaks, any things that you would say, hey, say some of your clients, right, where you got, okay, here's the contract, it's great, but this, like, hey, wow, this things are a little bit more riskier now.
It's a great question, Andrew. And if you've heard me speak before, you'll know that I always advocate having a written contract.
Yes,
And I've said before, it's a, they say that the best offense is a good defense. That's the only sports metaphor that I'll make. But that's how I see having a contract. It's a little bit of an upfront investment, but you can get a contract that you use on all of your projects.
Yes.
You don't have to pay for it every time. You invest in it once upfront, and I think that it provides you with a lot of comfort as you go along. And so I don't necessarily think that the model that's going to be the perfect model for you is going to change based on COVID-19. But I do think that the risks that we're seeing materialize right now may be another reminder of why it's so important to have a good contract that's your standard contract that you use on every project, that you're comfortable with, that your clients are comfortable with, and that you feel provides you with the best protection for your company and your particular kind of business model. And I think that's really the message. There's nothing that I would say is more important now in terms of draws or how you're getting paid, but I think it's more important than ever. And I think we're seeing why it's so important to have that contract in place and to have a really clear set of guidelines that tell you and define your relationship with the person that you're delivering the project to.
Yeah, and I think it does bring up something. I'm not trying to contradict what you're saying at all. I just want to emphasize because I'm an ex-tradie. I get it. Okay, out in the field, what have you. I think it's really important that you guys have not just a contract, but for the different types of services that you guys do. So, Peter, on the maintenance side of things, or service versus say project-based versus like certain size of jobs, where, hey, it's this size, we need to really use this contract that's more suited for that size of job, like whether it's draws or what have you. So I think engaging with somebody like yourself, Kayla, to go, so that they can say, hey, here's the different services. And then it's like, okay, so for that service, then, this contract, it's a different game that you're playing with that, instead of going on a job and it's approaching for 3 months. Yeah, you should have something different if you're going to do maintenance contracts where you're going in like once a month. Like, you know what I mean?
Definitely. I definitely agree with that.
Yeah.
Andrew, before we go, there are two things that I want to mention. One, Curtis has asked the question of whether Peter could set up a retainer for his regular clients, and I just didn't want to ignore him. So, Curtis, I think that's a great idea. I mean, you can take a deposit, you can take a retainer, whatever you want to call it, and say we're entitled to charge against this retainer in the event that you, in the event that your account is 40 days out of date or whatever. That's a great way to go about that. The other thing that I want to say that's a separate topic, but Mark LeBlanc asked a really good question in the Champion CEO group yesterday, and I just wanted to have a chance to address it because I think it's a good question, and I think a lot of us are probably having questions right now about our employees and our employment relationships. I did post in this Champion CEO group a link to my firm's COVID-19 resource center that has a lot of information about employment issues that may be arising right now. So I encourage everyone to check it out if you have questions. But Mark's question was whether he can have his employees sign a waiver in the event that they get COVID-19 while at work. And I was thinking a lot about that over the course of yesterday, and I spoke to one of our employment experts about it as well, so that I would have the best possible information to give to you guys. And here's where I've landed. Technically, there's no reason that you couldn't have your employee sign a waiver for COVID-19. I don't think that that's the route that I would recommend, and I say that for a few reasons. The first is the employment expert that I spoke to actually made a really good point, which is that it may be taken in poor taste right now to have your employees sign a waiver that says that if they get COVID-19, they won't sue you. As a lawyer, I would tell you to do it anyway if it was going to protect you, even if it's in poor taste. But I think that the value of the waiver is actually pretty minimal. So usually my advice with waivers is, who cares if they're effective? Get them and we can deal with whether they're effective later. In this case, I actually think the waiver is probably not that effective. So the fact that it's in poor taste may be something you want to consider. But I also think you don't have to worry that much about the risks. And so here's all the reasons for that. The first is you have to take certain precautions as an owner to protect your clients. And it's reasonable precautions. You don't have to do anything crazy, but there are precautions right now that are being recommended for contractors and construction site safety techniques. You have to make sure that you're providing proper sanitation. You have to make sure that you're providing a place for employees to wash their hands properly. You have to make sure that you're providing an environment in which your employees can safely social distance. And if you're not doing that, that's a problem. And you cannot contract out of those obligations. So if you have your employee sign a waiver saying that if they get COVID-19, it's their own fault. Well, if it's your fault, it's your fault. And you can't contract out of that. So the waiver is not going to help you there. The next thing is if your employee does get COVID-19, it's going to be very difficult for them to prove that they got COVID-19 on your construction site. So that's also probably not a huge concern for you. I mean, they could have really gotten it anywhere. The third thing is, at the end of the day, COVID-19 is more likely than not going to be a 2 or 3 week flu-like illness that's not really going to incur any damages that your employee can claim from you, right? It's not like they're going to not be able to work anymore. In Ontario, we don't really have damages for pain and suffering. You can't sue your employee if you catch the flu, or your employer if you catch the flu while you're at work.
Exactly. Oh my God.
So, right. So I think we need to be a little bit mindful of the real gravity of the COVID-19 risk, which is we don't want it to spread because we don't want to overwhelm our hospitals. And we don't want people who are high risk to get it because we don't want, some people are going to die of COVID-19 and we don't want that to happen. But the reality is that if one of your employees gets COVID-19, they're probably going to be sick for a few weeks and then they're going to be fine. There's not a lot for them to sue you for. The final point is that if you've got employees, then you're going to have WSIB coverage. And if there are damages that your that your employee incurs because of catching COVID-19, and they can prove that they caught COVID-19 while they were on your job site, that's going to be covered by WSIB in most cases. So you're not really all that exposed as an employer. So I think there are a lot of important considerations that we need to take right now. The most important one being making sure that you're providing a safe work atmosphere for your client, especially if you're working in a construction industry that's still being considered an essential service. You are having your employees come into work. They are probably scared. You're probably scared. So, make sure that you're making sure that they can have somewhere to wash their hands. Make sure that you're providing them with an environment in which they can safely social distance. But I wouldn't be too worried about lawsuits arising out of the fact that your employee caught COVID-19.
Okay, that's great. Awesome. So listen, everybody, let's big thanks out to Kayla for taking the time today to answer a lot of our questions. I know there's some that she's going to be coming back to us on, which is great. And, I guess I definitely want to hear your final words, Kayla. My final words is this. Guys, this is not going to be going away anytime soon. When I say that's across a lot of different fronts. There was people not paying you way before COVID-19. Okay? If there ever was a time, when you have the time, to get these kind of contracts in place, I'd highly recommend you do it now. Because if you run into a situation when this thing explodes, and when I say explodes, we're going to be, the switch is going to be thrown, and there's going to be a shitload of freaking work that you guys are going to be asked to do. When is the highest time and risk that you're going to be facing people that can't pay you, or, where there's things are going to slip through the cracks? And Peter knows it, right, Peter? It's when the pressure gets put on the pipes. So take the time, strengthen your business. We talked on the financial front about getting loans. We're going to get through this, guys, but make sure you're setting yourself up, number one, to survive through it financially. Make sure you're setting yourself up to thrive through it so that you've got these contracts in place. You've had a call with Kayla. You've done the things that you need to do to strengthen your business, because there's no excuses. I know a little bit harsh with that kind of shit, but there's no excuses. These are the times when you guys can really leapfrog, differentiate yourself, and really dominate your marketplace. Because the flu is going to be around until way beyond my time. So thank you, Kayla. Thank you, everybody, for participating. You can keep posting your questions in the Champion CEO group for those family members. Kayla, what's your last words of wisdom?
Yeah, I think everything that Andrew said is absolutely right. This is a tough time, and it's going to end. We're all going to get through it. I love watching you guys post in the Champion CEO group. I love watching you guys have each other to ask questions to help each other. Everyone is really supportive. And I think that's going to help everyone here get through it together. And I think it's great. Some of you, because of the nature of your business, aren't going to be able to take on new projects right now because of Ontario's list of essential services or the list of essential services wherever else you live. And it's going to be a challenge. But I think that Andrew's absolutely right. I think that we can use this time to be thinking about strengthening our businesses, making our businesses the best that they can be, and knowing that we're going to get through this. We're going to come out the other end, and there's going to be a lot of work. And something I said on the last call was, just be mindful of the existing clients and relationships that you have, and be understanding if someone says, look, I'm putting a hold on this project, even though technically you're allowed to continue renovating my house because it was a pre-existing renovation, but I don't want anyone in my house right now. That sucks because it's a potential source of revenue for you right now. but be understanding. Tell them that you totally get it and you wouldn't want to put them at risk, and you're going to be right there as soon as this is over, and you're going to come back and you're going to finish the project. And I think that your clients are going to be really happy to know that you're putting them first. You're concerned with them. When this is all over, you're going to be able to go in and finish the work there, and you're going to get referrals from them down the road. So
love it. Love it. Okay, excellent. So listen, everybody, tomorrow for a lot of people it's Easter. So have a great Easter, everybody.
Yeah, happy Easter.
Happy Easter, everybody. I'm looking outside. I can't believe it. That it's snowing like crazy here. What is going on here? But hey, for us, welcome to Canada. But anyways, have a great weekend, everybody. Great long weekend for those of you that are having a long weekend. Stay safe. Leverage this opportunity. It's a once in a lifetime opportunity. And here's my very last question for you to think about. We're none of us are on this call and we're 15 years old. What's my point with that? We've all experienced times where we look back and go, I should have. Oh, if I only could have. Right? Make it that you did and used it and leveraged it. Right? These are tough times, but they're also great times to be able to look back on and go, I did something with my time. I strengthened my contracts. I got better. I got stronger. Okay. All right, guys. Catch you later.
Bye, guys. Thanks so much
Ciao.
for tuning in.
Take care. Ciao. Bye.